what we're going to do is David Graff, who's the general counsel and has some other title at Epic Advertising, is going to lead us off and is going to talk about, sort of set the stage in terms of the kinds of legal issues that we need to be concerned about. And then I'm Jeff Greenbaum. Actually, there I am from Frankfurt, Kurnit, and I'm going to then sort of talk about some of the basics of advertising law and some of the some cases that illustrate some of the things that are going on today that are important. Then Peter Marinello, who's the director of the Electronic Self-Regulation Program. Is that right?
Electronic Retailing
Damn!
Self-Regulation Program.
I can never get it right. It's because of the video. No, it's the video game one.
Oh, okay.
Electronic Retailing. Yeah, the two. I just exactly. And then, so Peter's going to talk about substantiation in terms of, when you make a claim, what do you have to do to back it up? And then finally, Len Gordon, who's the regional director in the Northeast region from the Federal Trade Commission, is going to sort of, wrap it all up and talk about, okay, now you've heard about what the issues are, let me tell you about what the FTC is concerned about and what you need to do when you leave the room. So, thanks for coming, and David's going to start us off, and hopefully we'll do this in a good, on-time way, and we'll have time at the end for some questions. David, do you want to stand, sit? It's up to you. Okay.
All right, thanks. Good afternoon. What I thought I would do is I thought I would try to describe or at least frame some of the issues that I think are hot topics in marketing, compliance, and enforcement. Quick background. Again, I'm the general counsel with Epic Advertising. Epic Advertising is a large, performance-oriented online marketing company. We work with a lot of affiliates. We work with a lot of advertisers. We're essentially an advertising network. So from my vantage point, legal, compliance, regulatory issues all fall within my purview. I have, I think fairly good insight at least into what some of the current hot button issues are today. So I'm going to sort of lay them out at least as I see them, and then our distinguished panel will sort of obviously add flesh to that and comment on them. So, jumping right into it, what are sort of the current sort of hot marketing issues involved in affiliate marketing, at least at the moment? Well, I'm sure you're all aware of this. I've certainly seen over the past several months a real emphasis on consumer products campaigns. And when I say that, I'm specifically referring to sort of health and beauty. Some people use the term nutraceutical campaigns. Those have been very, very popular campaigns run by multiple affiliates. The business model that underpins most of those products is a continuity program, so it is an auto delivery and auto billing program. And look, like many of you, at least those of you who are affiliates in the room, you know that these campaigns are pretty much everywhere. In more places than you would traditionally think, given drops in CPM prices, you see banner ads for these campaigns actually all over the place on tiered sites, like top-tiered sites like abcnews.com, et cetera. There's been a wide proliferation of these. There are a lot of issues associated with these sorts of campaigns. They can be done well, they can be done ethically and responsibly, but there are a lot of issues associated with them. And it's actually kind of a good example to use to begin to kind of highlight some of the issues that affiliates need to be concerned about. So just focusing on these types of campaigns, and I'm just going to do a quick run through of the issues that I see, and then I'll let others comment. In no particular order, what do we have? One is issues surrounding disclosure of the terms of purchase. Right? These are continuity programs, and consumers obviously need to be aware of what they're signing up for and the relevant terms of the program. And there have been concerns raised, legitimate concerns raised about the disclosure of those terms. Are they proximate? Where are they located? Are they in a place where the consumers will actually see them and understand what they're getting into? Another issue, particularly with these campaigns, is the use of consumer endorsements and testimonials. There's lots of people, particularly affiliates, who use consumer endorsements or consumer testimonials to help describe and articulate the benefits of the product. And of course, there have been questions raised about whether or not those are legitimate consumers, if they're real people, are those folks being compensated for their testimony? Obviously, an important issue, and an area that Mr. Gordon will talk about, but an area, of course, that the FTC has long had concerns about, the use of consumer endorsements. A couple of other areas. The use of, well, let's focus on this one. The claims that are made about some of the health products or beauty products. I mean the efficacy of the claims. some of the claims are sort of probably borderline aggressive, and there have been concerns about people making fairly outlandish claims about what their products can accomplish, that they cure cancer, that they will prevent a particular type of disease, when the science just isn't there to back that up. There is it's perhaps more art than science, but there is certainly a way that any responsible advertiser can describe the potential benefits of their particular product, even if those products have not been the subject of extensive testing. But affiliates and everyone need to be careful about the type of representations that they make, and the substantiation requirements, which with others we'll talk about, apply to everyone that's making claims about the efficacy of a product. So substantiation and aggressiveness of claims. And then last but not necessarily least, and I'm going to lump a couple of these things together, use of celebrity photos and celebrity endorsements, use of trademarks and logos from other companies. We've seen affiliates and other folks use use celebrity images, use logos and trademarked items from other companies sort of on their pages to help present a visually compelling page for the consumer, but it's obviously problematic. That falls more probably in the realm of a private right of action. That particular celebrity or owner of the trademark is the aggrieved party in that case. But it's a concern if you're an affiliate and you're using those sort of trademark terms or those images without permission, you can get into trouble about it for doing so. How do you, very, very quickly, and then I will turn this over, how do you deal with these? How do you address these issues? I'll tell you a little bit about at least how I try to address them as sort of head of compliance for my company. One, with respect to consumer testimonials and endorsements, I mean, we require our advertisers and anybody who's going to use an image to have signed attestations from the folks that are providing this testimony, affidavits saying that this is my picture, this is a before, this is an after picture. I actually talk to these companies and interview them. I want to know who these folks are, how long have they known them, how did they find the particular consumer who's given the testimonial, are they being reimbursed for it? There's really no magic bullet solution to this. You just have to do some homework. Other things that we do, I review the ad copy very carefully, and we have rules about where the material terms of the offer needs to be disclosed. And this shouldn't come as a shock to anybody, but for continuity programs, I mean, our rules are you can't have the terms buried someplace in a hyperlink at the bottom of the page with terms in white on white font at the very bottom, linking to a pop-up box that has then the pricing terms buried within it. Right? For us, and the FTC has issued guidance in this area, the terms have to be disclosed right on that credit card submit page, so consumers understand what they're getting billed for. I'll stop there because I think the panel will be helpful here, and then I'm going to circle back with some questions. But maybe just as an overarching framework, again, these are some of the hot button issues that I'm seeing. Again, there's no sort of silver bullet to this. I think that sometimes when I've seen affiliates get into a little bit of trouble, I don't know how to say this other than to say it this way. It's more, I don't want to call it laziness, but it's more lack of attention to detail than it is necessarily malevolence. You just need to think about some of these things. You need to think carefully about the claims that you're making in a particular conversion page. You need to think carefully about the claims that are being made for a particular product. You need to think carefully about where, if you're using and if you're creating sites that are promoting other campaigns, the type of images you use, the type of representations you make, the type of testimonials you'll use. If you think about those issues, and use your common sense, you'll be able to chart a course that will allow you to both promote your business and to make money, but also to do it sort of ethically and responsibly. So that's my overarching framework. I'll turn it over to you.
Thanks for setting the stage. So, you said one thing which was interesting to me, which I didn't even occur to me to cover in this panel, and should be a panel all by itself, which is a little bit of some of the basics of using other people's intellectual property. And one thing I wanted to say, which I just thought was worth emphasizing, which is that people often think that if you use a celebrity in a truthful manner, that somehow is permissible. that, I mean, in the United States, the right of publicity is essentially that if you use someone's name, picture, likeness in advertising, you need to get their written consent. And people often think, well, but if I see a celebrity using my product, or I say something truthful about a celebrity, isn't that okay? Doesn't the First Amendment give me that protection? The answer is almost always the answer to that is no. And the reality today is with the internet is that there are people out there looking for these kinds of uses, and these are big claims, big expensive claims. So I think it's just I didn't want that piece of advice to be lost on you, which is one simple thing you can put on your list not to do is to take some celebrity and stick them on in your advertising on your webpage, because certainly it's an easy claim for someone to bring, and it's an expensive one. So now I want to talk for a little bit about some of the basics of advertising law, which in some ways will set the stage for most of the kinds of promotional things that people will do. I always start every presentation like this today and say, what is advertising? And the most important thing to take out of this moment is, there is nothing that is traditional advertising anymore. Everything that you do, every way that you communicate with consumers is most likely going to be advertising. It's important to remember that, because when you start to think about compliance issues, well, do I have to, do I have to make sure it's true if I say it here, or what if it's on a blog, or what if it's in a news article, or what if I put it in a press release, or what if I do it this way, or what if someone else does it? Remember that anything you're involved with, every communication with consumers is most likely going to be advertising, and you should treat every consumer like you would every consumer communication like you would the most traditional advertising materials that you create. It's a tremendously important point. One of the things that we're seeing, and we're going to continue to see more of, is advertising in non-traditional media and enforcement leading out of that, because people thought, well, hey, that wasn't normal advertising as we're used to defining advertising, and as a result, I don't need to follow all the same rules. This is actually an NAD case. It's a screenshot from the National Advertising Division, which is one of the self-regulatory bodies in the advertising industry, and this was a viral video that was put on YouTube by a Bluetooth manufacturer. And if any of you saw this video, it was essentially, you put the cell phones together and you put the popcorn kernels in the middle, and you turn the cell phones on, they all ring, and supposedly the rays come out and it's so hot and they make the popcorn pop, which of course doesn't really happen. This was just a video on YouTube. There was no advertiser disclosure. You didn't know whether it was advertising or not. You didn't know who the advertiser was. There was nothing about this that would suggest that it was advertising, and there's no mention of the product. There's no one's got a Bluetooth headset or anything on there. And the NAD said, look, even though you didn't mention that there was an advertiser, even though you didn't make any product claims, even though no one would even know that as a result of this you were supposed to go buy some sort of specific product, they said this is advertising and it's false and the advertiser shouldn't be running it. And they said another important factor here was that you needed to disclose, in fact, that it was advertising and who was sponsoring the advertising. The idea here is this basic principle that in most cases consumers have a right to know that they're being advertised to, and they have the right. The only way that they can judge the claims that people are making is if someone is clear with them who is actually making those claims. So even something that has no product claims, no advertiser mention, still advertising. So what rules apply? One of the complications about advertising compliance and marketing compliance in the U.S. is that there is not one set of rules. You've got federal law, you've got state law, you've got a lot of important self-regulatory guidelines that are out there. So it's important, as you start to think about some of these compliance issues, is you have to ask all of the right questions, because it's not just always going to be one set of rules. We're all freaked out right now because there's a statute that just got passed in Maine, which essentially prohibits the collection of information to kids under the age of 18, and also prohibits all marketing, essentially, to kids under 18 using that personal information. It's sort of a statute that sort of slipped by everyone's attention, but anyone who is doing anything with kids today, and kids, including people up to the age of 18, it's really turned marketing on its head right now, and no one really knows how this is going to play itself out. But again, who's thinking about Maine on a day-to-day basis when you're thinking about advertising compliance? But that's why it's really important to think about all the potential issues that are out there. So, as an introduction to, well, we can't talk about every law today, we can at least talk about Section 5 of the FTC Act, which prohibits unfair, deceptive acts or practices. And there's sort of two prongs there. One's the prohibition on unfairness, and one's the prohibition on deception. Deception is a misrepresentation or an omission that's material to consumers. And unfairness is a practice that's going to be harmful to consumers. So, what is the deception prong of this? What is deception really about? Deception is about telling the truth. It's as simple as that. Sort of David said, if you take a step back and you go and you look at the advertising, you go, hey, are we telling the truth here? is it misleading to consumers? On some level, advertising law, at least when we talk about basic advertising compliance, is as simple as that. Either it's true or it's not. I think an important corollary that's developed out of the privacy world too is that truth is not just about telling the truth, but it's about keeping the promises that you make. And we'll talk a little bit more about that. Another important factor, another important thing when you think about deception, which is often lost, is that you are responsible not only for the express claims that you make in your advertising, but for the implied claims that you make as well. So it's not just the words on the page. Even if the specific literal words that you've got in an ad or in an email or in any kind of promotional piece are true, if the consumers are going to take away a misleading impression, if they're going to understand it to communicate something else, you are responsible for that communication as well. It's a very, very important principle that being truthful is not just about the words, but it's about when a consumer is done looking at the ad, did they come away with a misleading impression? And Peter's going to talk about the substantiation point here. So, recent case from February this year. I like it because it combines both advertising and privacy. It's a CVS, basically a case the FTC brought against CVS, and CVS was making a privacy promise. The promise was essentially, nothing is more important to us than protecting your privacy. Now, you could apply this in any context, but what I like about this is that what the FTC said here is, look, you're making a promise that you're going to protect people's privacy, but you weren't. You were instead throwing their personal information into a dumpster that anyone could see behind the store. So that was a misrepresentation because they said they were going to do something, they didn't do it, and they entered into a consent order with the government. But this has application to any kind of advertising claim that you make, which is if you make a claim or you make a promise, you got to live up to it. It's also the reason I picked this case, not a traditional advertising one, was because it's a reminder that privacy is also one of these incredibly critical things today. That fraud, privacy, those are the two things, probably the single biggest things the FTC has said again and again, year after year, that they're concerned about. And we got to treat privacy compliance almost just as important as we would as any other kind of marketing compliance. Disclosures. David also sort of touched on, hey, how do you manage these disclosures and what's the standard here? And the reason for using a disclosure is not so that the information is theoretically accessible to consumers. It's to make the communication clear. And that's a very different standard. I mean, you could think about, hey, if you want more information about anything we've told you, call this 800 number or click here and we'll give you all the information you need. That's not the standard today. The standard is that the only purpose, other than a required disclosure for some regulatory purpose, the purpose of a disclosure is to communicate the information, the qualifying information you need to make the claim true. So, you think of a claim that something is free. If it's free only with the purchase of a $19.99 a month plan, and we'll talk a little bit more about that, well, that's an integral part of the claim that would need to be disclosed right with the word free. So remember, the idea of a disclosure is not that it's something that someone could find if they look for it. That's because we don't place in sort of advertising law, we don't place a very high burden on consumers. Consumers are not expected to be able to go out and look for things and dig through it and read it and figure it out. It's not that it's there for them if they looked for it. It's that we have to give it to them. We have to make it obvious to them. And so a disclosure needs to be clear and conspicuous. It needs to be something that when you see the claim, you also see the disclosure, so that again, when you're done looking at the ad, as a reasonable consumer would do, you're not misled. Disclosures are judged by a performance standard. Think about that for a second. They're judged by a performance standard. That means that a disclosure is only effective if it worked. So the fact that it was there, the fact that a consumer could have seen it doesn't matter if in fact when a consumer is done looking at that ad, they were misled. A lot of the debate that people have about disclosures is where do we have to put the disclosures? Do we have to put it this far away or in this color or in this contrast? And the FTC long ago in its online disclosures guidelines gave people a lot of guidance in terms of how to do it. But again, it gets back to sort of a common sense notion of a performance standard. Is it you look at these things, you look at a claim, do you see the disclosures? Are you exposed to it in one logical way so you understand what's going on? Recent case, there's been case after case in Florida, these free ringtone cases, and what I love about it is this, as part of this, there's all of this sort of discussion of color contrast and what level of contrast is acceptable. And again, I don't think that these cases, although these cases have been very influential in the industry, and although they've changed, I think, the way a lot of people have advertised, at the end of the day, there's nothing groundbreaking about any of them. These are all saying the exact same thing that have been said by the FTC and by other regulators for many years, which is that if it's clear and conspicuous, if the disclosures are in close proximity to the claim, if consumers are going to see them when they're exposed to the advertising, then the advertising is not misleading. Now, the reason for not making a misstep is that if you do make a misstep and you do end up in a regulatory, in sort of an enforcement situation, the problem is that the requirements of any kind of consent order that you would enter into are going to require you to, are going to require far more of you than the law would. And so one of the, other than complying with the law, one of the great incentives for not getting in trouble is the fact that if you do get in trouble, either the FTC or a regulator is going to require you to do a lot more. And you're really not going to be, I think many would say, on a level playing field, because you're going to have to do more that you're not going to have the options that other people will necessarily have. Another fascinating case that came out this summer was a case that the FTC brought against Sears. And what was interesting about it is it was another kind of disclosure case. In this case, you were joining an online community on Sears, and Sears had told you that we're going to track your online browsing. And this is really, I put this up here to remind me to mention how important sort of behavioral advertising is right now, and again, another big FTC focus. But what's fascinating to me about this case is this is a case where consumers clicked through on a contract. And I think there's the page where they were given a typical page where you sign up and you provide your information, and then someone said, wait a second, before you take advantage of this offer, you have to read our terms and conditions. You're required to scroll through them. You're required to click on a box that says, I agree to them, and then you agree and you submit. And so you think, well, wait a second. Here's a consumer who's looked at our site, who's signed up, who's scrolled through our terms and conditions, who's clicked on a box that says, I agree to those terms and conditions, and then has agreed. Again, they're not required to sign up for this site. It's not like they're purchasing insurance at the counter before they rent a car, and off they go. Well, the FTC says it's not sufficient disclosure. The FTC says the fact that something's buried in the middle of a box here of disclosures that they're not going to read when they're on that site, that's not going to do the trick. And so, what does that tell you? What that tells you is that often the protections that that online marketers have been relying on for many, many years, which is that, well, it may not be super clear, but we can get them to agree to it before that they sign up, and contract law says if you agree to something, you agree to something. Well, you may, as a matter of contract, have a contract with consumer, but as a matter of consumer protection law, you may still have a consumer protection problem. So don't think that you can solve, through a contract disclosure, deception that's occurred in the advertising. If there's something that consumers need to know, if something about the promotion is going to be unexpected to them, it's not going to solve the problem putting in the fine print. It needs to be up front. It needs to be something that consumers are going to see. David also mentioned, endorsements and how endorsements have become certainly a focus of an advertising practice as well as a focus of regulatory interest as well. There's no magic to endorsements, as David said. Endorsements have to be real. If a consumer, if an expert, if an organization gives an endorsement, it has to be their actual unbiased opinion. What does that mean? It means that first you have to get the opinion in a way that's not going to be biased. That means that if you call up a consumer and say, hey, we'd like you to be in our ad, could you give us an endorsement? Well, that's not an unbiased opinion. On the other hand, if you get an unsolicited letter from a consumer who says, just want to let you know, I tried your product, it worked great for me, hey, that's an unsolicited endorsement. That's one that, that regulators or others would say, hey, that's one that, has some possibilities. However, it's important to remember that an endorsement not only has to be real, but it has to not communicate any kind of false claims. And what does that mean? Well, it's not enough that the endorsement is real. It's not enough that the endorsement itself is true, but the endorsement has to not communicate. You can think of it as one of two ways. One, you can think of it as typicality. Is the consumer communicating information that reflects a typical performance of a product? So, consumer uses some sort of diet plan and they say they lost 100 pounds. Well, it may be true that that consumer lost 100 pounds in that diet plan, but is the typical consumer going to lose 100 pounds in that plan? If not, you've then got a misleading communication as well, because consumers who see it are going to think, well, that consumer is saying they lost 100 pounds, so that means I'm going to lose 100 pounds too. There's an FTC review going on right now of the endorsement guides, and the FTC's endorsement guides gives a lot of guidance about how to do endorsements, something if you're interested in, you should take a look at. But one of those issues that's sort of being debated right now is this whole notion of typicality, that what do you do about unusual performance of a product? And what the FTC is saying to us essentially is that those kinds of disclosures that we've gotten used to seeing just don't really work, and that we're now going to need to do more. We're going to need to be very clear with consumers that when you show performance that's not typical, that we're going to need to explain to them that it's really not typical, what the expected results are going to be, because the communication that consumers are getting, even with the results not typical or a similar disclosure, is just not working. Another fascinating issue, which is going to come up, I think Peter's going to mention as well, is this whole notion of bloggers and what does it mean? What does it mean when people are posting comments online? What does it mean to be a blogger online? I'll give you one example. This is from the New York State Attorney General from last month. Great case, Lifestyle Lift, sort of a cosmetic surgery firm. To drum up business, what the New York Attorney General alleged that they were doing is they were using their own employees to post comments online. It's a shockingly, or maybe not shockingly, familiar practice that marketers are using, which is they'll go to various sites and they will post comments. Hey, I had a great experience with this company. Of course, they're not disclosing that they're employees of that company. Well, New York Attorney General went to them. They also created some fake websites too. Employees would create a site like Consumer Alert Report, what every consumer should know about Lifestyle Lift. Appeared to be an independent site reviewing the company. In fact, it wasn't. In fact, it was an actual employees creating it, making it appear like an actual site. So again, New York Attorney General saying, look, deceptive practice here. These are not real endorsements. If the company is speaking to consumers, they need to be honest that it's them that's speaking to consumers. This is just my favorite quote when I was thinking about this, was that this is an email to one of the employees. Put your wig and skirt on and tell them about the great experience you had. Obviously, not only do you not want to do that, but you don't want that email to come out when the investigation's happening. Finally, unfairness. Unfairness has taken a much larger and more important role, I think, online. Unfairness, again, is about harming consumers, not necessarily about deceiving them. And I just wanted to finish up and mention unfairness because sometimes a marketing practice, even when you're telling a consumer the truth, can still be harmful to them. My favorite case from several years ago, which I still love to talk about, is a case brought against D Squared. And this was a case where D Squared was using Windows Messenger to send pop-ups to people's computers. So they were taking an available technology and they were sending pop-ups, but they were sending a lot of pop-up ads, and they were sending them even when you're not necessarily online. So it was an ingenious use of technology, reaching consumers at their desk. And what were the pop-ups advertising? Of course, they were advertising software to make the pop-ups go away. And you take a step back and go, well, there's no deception there, right? You're not lying to the consumers. You're just advertising to them using the technology that's available to you. But what the FTC alleged was that this was an unfair practice because you were harming consumers by doing all of these things to them that they could not avoid. But what I loved was some of the allegations in terms of from the FTC's complaint were, what were the damages? Losing work productivity, having their computer screens freeze, suffering an increasing level of frustration and annoyance. The point here is now, this was a really, this was an extreme situation. It was significantly interfering with consumers' use of their computers, but it's an important reminder that as we think about new technologies, as we think about ways to communicate with consumers, as we think about ways to reach consumers they don't expect, even if we're not lying to them, even if we're not misleading them, we still have to make sure that the practice itself is a fair one and that it's a reasonable way to be reaching consumers. Because if we don't, there still could be FTC action. Finally, if I had another hour or two to speak, I would talk about these topics. These are some of the things I think that are on my mind. Not all of them are FTC or regulatory issues, but certainly ones that when you're involved in, you got to take a step back and go, hey, these are issues to be concerned about. Now we're going to turn over to Peter, and Peter's going to get into some cases and talk about substantiation.
Love the case about the pop-ups, trying to avoid the pop-ups. Reminds me of the ad.
Now let's see, Tuesday. This is Tuesday, right?
So Jeff, reminds me of the ad.
Okay.
How to avoid rip-offs. Send $15.99 to P.O. Box, blah, blah, blah. Same idea.
I think this is you right here.
So I'm going to come at you from a little bit different angle. I'm going to come at you from, I'm going to talk a little bit about self-regulation, what it is, what we're all about. Again, my name is Peter Marinello, and I direct the Electronic Retailing Self-Regulation Program. Better known to our good friends and family as ERSP. And I help administer the direct response industry's system of advertising self-regulation.
Hey, which one of these is yours, you know?
I think it is, let's try this one, Hot Topics in Marketing.
Yeah, there it is, but there's no PowerPoint. Oh, there it is. Do you want which one of those?
I think it is, not
no,
that one.
There we go.
Let's try that one. Always the most challenging part of doing this is figuring out the whole PowerPoint angle. They don't teach you that in law school, so they should actually give you classes in that. So there you have it, ERSP. Now, ERSP is actually, it's administered by the Council of Better Business Bureaus. And it's a program of something called the National Advertising Review Council, which is a group of 7 advertising trade associations. And the unfortunate acronym of the National Advertising Review Council is NARC, so please don't leave the room yet. In any event, here's how IRS started. Its origins trace back to, all the way back to 2004. And it was really started at the behest of one of those 7 trade associations called the Electronic Retailing Association. And here's what was going on. Back in the late 90s, as you all probably remember, the broadcast airwaves were being inundated with all these very egregious weight loss ads. And I want to provide you an example. Let's see how well I can do this. Let's try this one. No. Now, how can I click on that video? It's funny, we had this great clicker, and now it's kind of like my kids with the clicker. Someone ran off with it. Here we go.
You've tried joining gyms, you've tried working out, and you've tried all kinds of diets. It's just that nothing ever seems to really work for you. Until now. Now you don't have to find the extra time to work out. You can lose weight. You can drop those unhealthy pounds easily, quickly, and safely. With
Well, there should be a... No? Wait, yeah, there we go. What?
Oh, it's so good you want to. That is not the guy who did the ad. I know I sound like an infomercial spokesperson, but that is not the guy. It looks like I could pitch away. Look at this. It's like a fat magnet.
It's not coming out now?
You know, it's funny because now this guy, I've been showing him in presentations, he gets the last laugh on me. Good for him.
Yes, it just doesn't have the video.
Okay.
Sorry about
Oh, you know what?
that.
Yeah, exactly. Everyone on hold back here will break into groups. All right, let's see where I go from here. Okay, so I'm going to get just a little procedural info about IRS. Again, our purview is direct response advertising, where it's advertising where consumers are asked to place an order or obtain additional information regarding a product or service using some kind of electronic device directly with the advertiser or marketer. Again, the most popular one, of course, is the infomercial. Now, we had a couple of goals here, actually, when we started the program. The first was to restore consumer confidence in direct response advertising. We also want to set up a mechanism where we can really move these cases on pretty quickly. Third piece is to get the outliers off the air. Set up a system of review where we can, again, move the cases quickly and get the guys who are making the most egregious claims off the air. And finally, what we wanted to do is demonstrate the commitment to the FTC of this industry to very real commitment to voluntary self-regulation. Now, a lot of the claims that we see are a lot of the same claims that all of us up here see. We see the testimonials, and we see the endorsements and the demonstrations, and the clinically proven claims. And the one thing I've learned in doing this, believe it or not, I've been doing this for 18 years, is that advertising is advertising. And at the end of the day, you basically have to be able to substantiate the claims that you make for your product. And the real threshold, the evidentiary threshold of advertising really dates back to 1983 when the FTC kind of espoused its substantiation policy, where any marketers or advertisers are required to have a reasonable basis for any express or implied claims that they make. Jeff touched on it a little bit. Now, we don't have any kind of punitive damages from a self-regulation standpoint that we can impose on the marketer or the advertiser, unlike the FTC, which when they look at a reasonable basis, they take other things into consideration, the type of claim, the product, the benefits, the consequences of a false claim. We can't go there. They can hit a lot harder than we can. All we can really do, it's a voluntary process. We can only recommend that they make certain modifications to their advertising. Now, this is such a classic case. Is there any way this is going to work? This is the old rapid shave case. It actually dates back to the 1950s, has to do with demonstrations about a product's ability to shave on sandpaper, correct, Jeff? Now, what they actually did, though, is they used plexiglass to make it look like sandpaper. And even though they maintained that the product itself could perform on sandpaper, it was the use of an undisclosed mock-up that really ran afoul of the demonstration law. It's such a good one. It has Frank Gifford in it. And really, Jeff has seen it a million times. He's probably sick of it. But, it has this great little Walter Cronkite narrative, too. And it would have just been so timely, the great Walter Cronkite. But, oh, it's a good one. Well, did you see that one? See, it's a good thing you guys already had lunch. You didn't want to see this one anyway. No, Urine Gun, what Urine Gun was actually about, it was about this product that you spray on wood surfaces and it gets out this ridiculous smell, obviously, on wood surfaces, on tile surfaces, on all these different surfaces, but they never had the evidence showing that the product worked on all of these surfaces, which is always a good idea when you're coming before Leonard, the FTC, or myself in the self-regulation world. Anderson Doors, again, another video, had this great Johnny Cash tune. It was about a consumer endorsement. It was about this Donatello family who were subject to this great storm up in the Northeast. And it was about patio doors. Anderson has these great patio doors, and it didn't show any leakage at all in the patio doors. However, when we took a look at their evidence, there was storms of water that came through. They didn't even have the typicality disclosure that Jeff touched on, where results may vary. This is an extraordinary performance scenario. You could have at least thrown that one in there to maybe appease myself or, again, the folks at the FTC. We didn't even get that. The Velform Sonnerbelt, another great one, too, where this was a good one about consumer testimony. It's a shame I really have to explain this to you, too, because the visuals, in the infomercial world, we get to see all these great creative endeavors, and it's unfortunate, because a lot of times, the advertisers and marketers straddle the line a little bit with respect to their product claims, and it's such a great creative bunch, sometimes they get a little overzealous with respect to their claims. This was actually a case very much like that. Where it's this product you basically put it around your abdomen, you use it for 50 minutes and you lose all kinds of weight off your stomach and your abs and your thighs and everything else. However, their evidence showed that you lost only a minuscule amount of centimeters actually when you used the product, and the thing actually burned you. I hope there's nobody out there from Velform Sonnerbelt. Hopefully you fixed your product if it did. Okay, now a lot of claims that we've been seeing a lot out there are these clinically proven establishment claims. Again, clinically proven ingredient, clinically proven to work. Now these are probably the most aggressive claims that we see out there, because when you're telling somebody that your product has been subject to some degree of clinical scrutiny, it obviously sends a very, very strong message out there to consumers. So when we evaluate these clinically proven claims, we look at several different things. And I should note, I talked about a reasonable basis for general claims. When you're talking about health and safety claims or establishment claims, the bar gets raised a little bit. We're talking about reliable and competent scientific evidence. Now, the FTC has provided a very nice definition for us. It's actually a four-pronged definition. Test analysis, research, studies, or other evidence, one, based upon the expertise of professionals in the relevant area. Two, that has been conducted and evaluated in an objective manner by persons qualified to do so. Four, using procedures generally accepted in the profession to yield accurate and reliable results. Here's what we look for when we look at these clinical tests.
Just take a step back. This is so important. Just take a step back. Talk about reasonable basis for 1 second.
Right.
Like, give an example of a claim and what's a reasonable basis.
Well, a reasonable basis, let's say, for instance, I'm going to go back to the crazy urine gun case, okay? My product works on wood surfaces. What I'd like to see is some kind of evidence that you've tested your product on wood surfaces. What you have to do is match the evidence that you have with the claim that you're making. It's fairly easy. Now, again, with health and safety claims, establishment claims, bar gets raised a little bit. You're dealing with the health and safety of the population out there. A lot of times the FTC, for instance, will ask for 2 independent clinical studies. Again, we work under the auspice of reasonable basis. However, with these establishment type of claims, bar gets raised a little bit.
What about a product that has the same ingredients, it's not your product, and they're making the claims? Is that a reasonable basis?
No, I think there's a threshold that you have to show there. What I want to see is, first of all, that the ingredient's been tested at the same dosage level. Are there any other ingredients contained in that product that may offset the effectiveness of the ingredient as it's contained in your product? Those are just some of the things we look at. We also look at those sample size. Don't give us a sample size of 5 or 6 people. For a clinically proven claim, we actually like to see a much larger sample. Statistically significant results.
What if you're not the manufacturer? What if you're just advertising a product supplied by somebody else and they tell you that it does do these things? that substantiation?
Well, again, now, you're supposed to have this substantiation in your pocket before you disseminate the claim, right? So, you can use published articles, published resource materials, again, matching up the dosage level of that ingredient that's studied with the ingredient that's in your product. Is it, another key factor is the product being used the same way as it's being tested? The use instructions of the product and making sure that the use instructions of the product are consistently followed in the test. I mean, that's a major factor as well. Statistically significant results, usually it's done at a 95% confidence level, meaning that the likelihood of placebo effect or random chance produce those results is less than 5%. Again, this was the definition of reliable, competent evidence we had, and I'm going backwards, and let's see. Oh, here's a very interesting case, too. This case came to us by virtue of an email, and attached to the email was an advertisement for the product. In the advertisement for the product, it basically drove you to the website. Here you go, Hoodie of Life, the most effective, fastest weight loss supplement out there. It was also making clinically proven claims as well. It was also making quantified claims with respect to the specific percentage of fat that could be removed. Now, here's a situation where the guy said, you know what, Marinello, we don't want to come to your forum. They folded their hands and they said, forget it. You know what, no, nothing's going to happen. It ends up, Len and his buddies over at the FTC, they pursue the case. So it ends up, these guys get hit with a $3.7 million judgment against them, basically, because they tried to circumvent the arm of self-regulation. Now, here's an interesting case, too. This is the last case I'm going to show you. And this touches on something that both David and Jeff got into regarding the FTC guides on testimonials and endorsements. And this is something that I know the FTC is struggling with their revised guides. Here we have a product review site. Looks innocent enough. The most comprehensive database on the internet. Most popular product, Miracle Burn, fine. They're telling us Miracle Burn is the most popular product based upon the voting of their review staff. It's even the Editor's Choice Award. Looks innocent enough. However, something fishy is going on here. Challenger says, Pete, you know what, there's another site also making the claim, the most comprehensive database on the internet. Okay, guess who the most popular product is? It's Miracle Burn again. Also the Editor's Choice. Kind of get the feeling something fishy is going on. Another website, Google Diets, most comprehensive database on the internet. What's the most popular product, you think? Miracle Burn, Editor's Choice Award again. In fact, there were several other websites, look and feel all quite the same, making actually identical claims about the most popular, about the most comprehensive weight loss database on the internet, and also having Miracle Burn as the most popular product. It just so happens that the owners of Miracle Burn also owned all of these websites. However, there was no disclosure indicating that. What they also didn't tell us is that not only did they own Miracle Burn, but they owned several other products that were being reviewed on all of these websites. Jeff, what they also didn't tell us was that the people reviewing these products were actually being paid for their review. These are all factors that go to the material connection between the person telling us this message and the advertiser. As a matter of fact, I'm going to close on this too. This case right here is the subject of an article today in the New York Times in the business section. So if you want to learn a little bit more about it, it's actually in there today. You talk about a timely issue, right?
There you go. Thanks.
Thank you very much. Appreciate it.
Can I ask a question that's sort of relevant?
No, of course I do.
Jeff, you brought up a point that I don't know that I think it might be very relevant to this audience, which is an affiliate is post-creating an ad that's repurposing a claim that this advertiser has created, and that affiliate has no idea whether or not that's a true claim, a valid claim. In some sort of action, is that affiliate held responsible for propagating the message, or does it go back to the source of the claim?
That's the million-dollar question, isn't it?
And I think the answer to that, I mean, the scary answer for that is yes. The answer is that a regulator will, what a regulator will say to you is that you're the advertiser here, and you have an independent obligation to ensure the claims that you make are truthful and are substantiated. It's a very, very high burden. And it's a very scary one because you think of the number of people who are advertising products that they get from other people. And especially in an affiliate situation where, you may not have a direct relationship with the advertiser either, and so it's a very, very difficult and uncomfortable situation to be in. I mean, and I think that, I think there are probably two important things to say here. One, as a practical matter, there's probably a category of products or a category of claims that are probably obviously questionable. And those are ones where clearly you're going to want to exercise some additional due diligence. And it's a very risky area, and one thing, and maybe let it go with that, but yes, you're absolutely liable. I would be very concerned about it. And the U is also a scary thing too, which is that under the FTC Act, individuals are personally liable for violations of the FTC Act. That means that even if you've incorporated, if you're making false claims, let's say you go and you sell $1 million worth of products, well, the FTC is going to come back to you and say, you have to pay rest. If the product was found to be fraudulent, you'd be responsible for paying back that $1 million. They give the money back to consumers. Even if you said, wait a second, I don't have $1 million of profit here. I have $200,000 of profit. The FTC would say, well, that's okay. We want your $200,000 of profit, and then we want the $800,000 in your personal bank account because you're still responsible for that. So the consequences are quite significant.
And just to pick up on what Jeff said, the more outrageous the claim and the more consumers are injured, the more likely it would be that the commission would go after an affiliate or even the principal of an affiliate. Ultimately our job is to protect consumers, and if to protect consumers and to get money back in consumers' products from the sale of what we really consider to be a harmful product, we have to go after affiliates. We'll consider doing that. Let me step back a little bit. Again, I'm Len Gordon. I'm the director of the Northeast Regional Office of the Federal Trade Commission. The FTC has two principal missions. We have an antitrust function and a consumer protection function. For the most part today, I'll be talking about the consumer protection function, but I did want to remind everybody that we do antitrust. Among the things we look at are a lot of high-tech issues, and the thing you probably heard a little bit about recently involves Eric Schmidt, the head of Google, and we've been investigating whether his running Google and sitting on Apple's board presents a problem. And apparently it does, since he's resigned, and we're continuing because there's still an interlocking directive. So in addition to consumer protection function, we share antitrust enforcement with the Department of Justice. Our consumer protection mission is, it's really at a crossroads right now. We'll see what happens. The president has proposed the creation of a new agency, and at least as initially proposed, that agency would take all consumer protection for anything financial, take some of our jurisdictions, some of the Fed's jurisdictions, some of the Office of the Comptroller of Currency, the Office of Thrift Supervision, and put it all in one office. So we'll see if that happens. It's running into a lot of resistance on Capitol Hill, but it's an interesting time. We have a new bureau director. His name is David Vladeck. He's running the Bureau of Consumer Protection. He is, I would think, by far the most aggressive director we've had, and he's only been there a month. He is a brilliant lawyer. He's probably the best trial lawyer who's run that bureau in a long time. And it's almost a pun, but there really is a new sheriff in town. And in speeches, interviews, he's made pretty clear what his priorities are. It's poverty. So we've been spending a lot of time on this, but we're going to continue to spend a lot of time on advertisements, marketing directed at those who are suffering the most severely from the economic downturn. So, and there's a lot of this on the internet. Scams, schemes claiming to save people from mortgage foreclosure. Scams, schemes that claim to be able to reduce your credit card debt or to reduce your credit card interest rates. Job scams. Those are huge priorities. So if you're involved in the marketing of those in any way, I would advise you to be very, very careful, because we're talking about consumers who have 1 foot over the cliff and 1 foot on the banana peel. And we've taken a lot of heat from Congress about not doing enough, so we're doing a lot more. So if you're marketing those kinds of products, I would advise you to be very careful. Privacy is another huge area of concern. I'm going to come back to that in a minute because I think we're heading towards a new privacy paradigm. Protecting children. If you're marketing towards children, I wouldn't just be worried about the statute in Maine. I would also be very careful about the kinds of information that you're gathering. The last 10, 15 years, privacy has taken one of two, our approach, the FTC's approach to privacy has taken one of two approaches. One is notice and consent, and that is the notion that it's okay to collect data provided that the consumer consents. And Sears, you saw the example Jeff put up a few minutes ago, was probably following that. The problem with the Sears policy was it was written by a defensive lawyer. All lawyers are that way, I suppose. But it was like the 15th screen you would have to click to really understand what they were going to do with your data and what kind of data they were going to gather. It was supposedly to help Sears, it was promised to consumers to help Sears understand how people did some online shopping primarily at Sears. In reality, it captured all of your web transactions, pharmaceuticals, credit card purchases, everything. And even though it may have been buried in the 15th line of text, it was pretty clear to us, and we think the evidence was very, very clear, the consumers didn't understand that. And this is not a unique event. Consumers do not understand the terms and conditions that they are clicking through on mobile devices and on the internet. And it's especially true on mobile devices. The notion that a consumer is going to, on their little screen, click through 3 or 4 pages of legalese and understand what that means is borderline absurd in the view of the Commission. So if you think you can protect yourself by a 4 or 5 page, densely written disclaimer, I don't think that's going to work anymore. The disclaimers, the disclosures should be written with the same powerful terms and the same panache as the advertising. You can't have real catchy, easy to understand terms up front in the beginning of the advertisement and then disclaim or disclose or contradict that several pages later in a densely written disclosure or disclaimer. It's just not going to work, and it's really not going to work under the Commission as currently constituted. The other, and I should note that this notion that if you disclose it, you're okay, isn't unique to privacy and advertising. If you think about what's going on in the credit crisis, many of the consumers who are most dramatically affected by mortgages, by other credit instruments, signed a document that disclosed in some fine print somewhere in the 15th or 16th page the terms under which their mortgage rate could be adjusted, or the terms by which their credit card terms might change. But did that consumer really understand that? And the answer, we believe, is no. So the notion that just because a consumer signs something, the law will assume that they've understood it and agreed to it is changing. Behavioral economics, whatever you want to call it, the terms need to be explained to consumers in much clearer terms than they have been up till now. The other regulatory framework on privacy has been harm-based, so that if a practice, whether it's the gathering information, the use of information, harms consumers, and that harm up till now has been primarily an economic harm. Does it put them at the risk of having their bank account information compromised, their credit card information compromised? That can be considered unfair. David Laddick was interviewed by the New York Times this weekend. If you're interested in this stuff, I'd highly commend the article to you, and there's actually text and answers, questions and answers in text on the internet. He's floated the notion that harm may also include a dignity interest, that just as if you would find it somewhat intrusive, if someone followed you around the mall and wrote down every place you looked, every place you shopped, every window you stopped in, every person you talked to, consumers, if they really understood the way internet advertising works, would find it offensive, a dignity violation, if all of that was tracked from their internet surfing. And he is of the belief that consumers don't understand the way online advertising works, and the industry needs to do a better job of explaining this, both as an industry and as individual advertisers, and that there needs to be more opt-in, opt-out, and much, much greater transparency. Earlier this year, the Commission issued new self-regulatory principles for behavioral advertising. The industry has responded. The Commission has not formally commented on those principles, But the one thing that it's clearly lacking from the IAB, BBB principles is right now there's not a really strong self-regulatory enforcement component to that, and I think that's going to have to happen before the Commission's satisfied that a self-regulatory initiative is sufficient. What's not clear is what the new privacy framework should look like, and I think that framework will also inform all kinds of disclosures on advertising. You'll see, I believe, in the near future, a real effort by the Commission to gather industry leaders, thought leaders on this area to try and come up with a better way to A, educate the public, and B, give business some guidance as to where the lines are. I mentioned the poverty initiative. There are some other areas that are of particular concern to the Commission. Green advertising. Today, the Commission issued, I think, 3 consent decrees and an administrative complaint against companies that were selling products that supposedly were made of bamboo fabric. And many of them also had antimicrobial properties because of the bamboo product. The stuff was rayon. Not a real close call, but I think you're going to, and you'll see most of the green claims thus far are not close calls. But again, if you're doing affiliate marketing on green products, think about who you're doing business with. We sued Kmart and 2 others this year over false biodegradable claims. There is a survey out to consumers that we've issued to try and better understand how consumers interpret green claims. What do life cycle claims mean to consumers? Do they impact consumers' purchasing decisions? And hopefully we'll issue new green advertising guidelines sometime in the near future based on the results of that survey so that business has a better sense of where the lines are. The other thing that advertisers should be cautious of are promises of free stuff. If you are touting free stuff, it better be free. About a month ago, we sued John Beck from the John Beck Free and Clear get-rich-quick scheme fame. If you're out in the West Coast, he's all over the place, and he's on TV as well. The, quote, free trial offer was really an enrollment in a continuity plan, and he sold $300 million worth of this stuff, and it's the intention to recover that money. So we'll see how it goes, but if he doesn't have it, we'll look for, I assume, some of the people he was doing business with. In late 2007, early 2008, the Commission sued 3 companies, all of whom were promising free goods on the internet and through spam email. It was essentially breakage marketing. You had to go through window after window after window after window after window to finally get sometimes to the free offer. Oftentimes you had to buy things to ultimately get to the free offer, or you had to divulge sensitive personal information, and we sued those guys. So if you are marketing with the promise of free, it needs to be free. The fewer strings attached, the better. Health and safety remains a top priority. The more serious the disease that you are claiming to have a solution for, the greater scrutiny you can expect. Today, the Commission announced a decision by an administrative law judge against a company that was touting over the internet phony cancer cures. There should be another decision in a similar case within the next month. More to follow here. I mean, I expect that we'll be partnering further with the FDA to really go after the companies who are preying on desperate consumers suffering from serious health problems and who are willing to try anything, and we feel like we need to help protect them. Earlier this year, the Commission sued Kellogg's over claims it made about Frosted Mini Wheats, and Kellogg's was touting that if you gave your kid Frosted Mini Wheats in the morning, their attentiveness in school would improve by 20%. The only problem was there was almost no scientific evidence to support that. There was some evidence that perhaps as much as 11% if the kid didn't eat anything that morning, but maybe 1 kid out of 100 had a 20% increase. That's not typical. And if you're going to make those kind of claims, the evidence better be typical. Earlier this year, the Commission announced a settlement with QVC. QVC paid $6 million in consumer redress plus $1.5 million in civil penalties for violating a prior FTC order. They were selling weight loss pills, food bars, energy supplements, Be Alive, which supposedly was made from some honey. All of this had no science behind it. All of it was false and unsubstantiated, and it cost them ultimately a lot of money. Let me close on the endorsement guidelines. They've gotten a lot of publicity. Two big issues. Typicality. If you're going to sell a weight loss claim and have somebody saying, I lost 25 pounds on this, you are saying that in your advertisement because you want consumers to think that if they use this product, they're going to lose 25 pounds. Well, if that claim is not typical for the users of that product, that claim, in our view, is false. So be very careful before you make that kind of a claim. The other issue is affiliation. You saw some pretty heinous examples of bloggers and such who were being paid by the companies that they were promoting. And that's an area that's gotten a lot of attention. There's a lot of mommy bloggers out there who are very, very upset that we're taking away their supply of free diapers. That's not really the intention of this. But if it would be important for a consumer to know that the person whose review they're reading is being paid by the promoter or manufacturer of the product, that should be included in the information that you're providing to the consumer and should be provided in a meaningful way along with all the other information that's in there. And with that, I will wrap it up and wait for some questions.
Great, thanks, Len. So we have a minute or two if anyone has any questions. I know we talked about a lot.
I don't know if this is the proper session to put this question, but what's the case with Google, for example? Because we don't know what they are, how they're using our information. We don't have any place to disclose how, and they almost always offer new products, and they use our information for these new products to develop other stuff, like the Google Phone one. And it's kind of crazy the way they are taking over the world. And, for example, they come to...
Allegedly taking over.
Yeah, no, and I just think on Sunday they had this how to perform Google Ads. It's great, interesting, but they don't even mention that you can have free links on organic search for free, and they say they don't have numbers if people prefer the paid search or the organic search for the Google. How they don't know that? So, I don't know, it's kind of obscure.
I mean, other than the little chips that they've managed to put in everybody's heads. No, I did one of these panels a couple of months ago, and I was sitting next to somebody from Google, and Business Week had come out that morning, and it had, how Google controls the world on the cover. Google's privacy policy and disclosure policy is probably one of the clearer ones out there, but this highlights the issue I addressed earlier. A lot of consumers don't understand the way internet advertising works. They don't understand that the reason they get to look at all these websites for free is because their surfing information is tracked so that advertisers are willing to pay more for ads targeted to what they want to look at. I mean, the people in this room understand that, but there's a lot of consumers who don't. And as a society, we're going to have to wrestle with how to deal with that. Do we have, every time you go to a website, you have to opt in to have your information shared? That might be cumbersome. Do we go to a place where most websites you have to pay if you want to look at because the advertising revenue that heretofore made that website available is no longer available. That's a debate that I think we're on the precipice of having in this country, but I don't think up till now we've really had it in a meaningful way.
Somebody else? Yes, in the back.
New York Times, last week, one day there's an article about behavioral targeting, privacy policy, all the things we just discussed, and the risks for consumers. Next day, big glowing article on the future of addressable set-top boxes, customized delivery to the consumer in the home via the cable company. And it was an odd juxtaposition because there wasn't a mention of any consumer risk, and it was all about the upside. The day before, the online site was all about the downside. Where's the balancing point, or is this a chance to get ahead of it?
Well, I don't know. My view about that is I think actually the FTC has actually been pretty sensitive to those issues, and they tend to engage in a fairly long and public process that's pretty deliberative on these issues, and the FTC is actually weighing those issues. And I think when you look at sort of the all of the statements the FTC has made about in the behavioral space, for example, they talk about the benefits and they talk about the risks, and I don't think anyone has any good answers. I also think we're at one of those moments where the technology is changing dramatically, or we've been in one of those moments for a long time now, but the technology is changing dramatically. The way we communicate with consumers is changing. The way people advertise is changing. The devices we're using, the way we collect information is changing. And the rules that are going to make sense right now probably aren't going to make sense 3, 4, 5 years from now because consumers are going to understand it. I mean, one of the things that I remember one of those old FTC cases was when you sold hair dye, permanent hair dye, there were cases that you needed to disclose that the hair dye wasn't permanent and that the new hair that came out in your regular color. And on some level, we're at that one of those moments right now, which is that we sort of have to say to people, when you're on the internet, certain things are going to happen. And consumers just, there's certainly a concern out there that consumers don't understand certain things that are going to happen. But we're going to get past that point. We're going to get to a point where consumers do understand how things work, or we're going to have a new set of standards, and we're going to have a new set of challenges. So I think that no one knows how to deal with all of these issues. Everyone's struggling through them. The government's struggling through them. Industry's struggling through them. And I think it's a tough balance.
Yeah, and I think one of the things that makes it especially tough is there's a real generational divide. There are people probably 25 and under who are completely comfortable having their entire life on the internet.